Good day to you, and welcome to another Paddocks Club tutorial. This particular one arises from a discussion that I had with Frederick Nell of Pretoria, Marianne Anderson of Howick, and Myburg Brink of Cape Town on the question of owners' gas-powered cooking and heating systems. And underlying the discussion was, what is the body corporate's responsibility? Let me give you a quick overview. I'll suggest a basic approach. We'll talk about insurance and safety issues, the use of the common property, ask whether there are any other regulations, and have a quick look at the Occupational Health and Safety Act. So what should the body corporate's basic approach be? Well, the first issue is the gas cooking or heating taking place inside the section, or is it in fact outside or partially outside? If it is something legal that owners are doing within a section, even if other owners don't think it's particularly sensible, oh no, gas cooking is fundamentally dangerous, some people might say, but owners and trustees don't automatically have the right to impose their views on the resident of a section. If, of course, the activity or the installation is partially outside the section on common property, then the body corporate probably would be involved in one way or another. Let's look at the most important things, safety and insurance aspects. If the action could endanger the buildings or anything the body corporate is responsible to maintain, even if it is happening in a section, then it has an interest. The body corporate and the trustees particularly have an obligation to make sure that the building's integrity is maintained. And they must do whatever, in practical terms, is necessary to ensure that happens. In the same way, it could, in fact, activity within a section could increase the risk of an insured event. The body corporate must inform its insurer of this situation at the same time, so as to ensure that its cover remains valid and enforceable. But let's look at the common property. That is the part of the scheme that's owned by all owners of sections in undivided shares. If, for example, the gas cylinders are outside the section, kept immediately outside, perhaps a hole put through the wall so as to allow the gas to come in. The first question to be asked is this an exclusive use area, or is it unregulated common property? Owners can't simply go and appropriate a portion of the common property to put anything, air conditioning, condenser units, gas cylinders, anything else. This is something that has to be dealt with as a body corporate issue. And the question will be asked, should it be allowed or not? And if so, is there any permission? Is this permission by trustees? Is it permission by owners? Is a use right required? Do we have to say, look, if you want to put it outside, we're going to have to ask owners whether they're prepared to give you exclusive use to a particular part? And do you need to put a concrete slab down to make sure that the thing is safe? And what exactly is it going to look like? Will it be unsightly? Is it going to reduce the value of all our properties because it's so ugly? The other thing one asks is, are there any other regulations applicable? Is there anything in the Act that deals with this, or the scheme's own rules? Are there any national or provincial laws, or even local municipality bylaws that have particular requirements? Sometimes the trustees will know these things because they've dealt with it before. The managing agent might have dealt with it in other schemes. But if not, one of the questions that has to be asked is, who has to do the running? Do we have to find out whether it's all right, or if you make an application to put your gas bottles outside, can we not say to you, well, all right, go and get us some sort of certificate, some sort of proof that in fact this thing doesn't require any other permissions? Finally, it was a question Myburg raised. Does this in fact fall under Occupational Health and Safety regulations? Well, the Act, the Occupational Health and Safety Act 1993, is fundamentally a piece of legislation enacted to protect workers in the workplace, but it does also impose obligations on property owners. In this particular case, if there's a portable stove inside a flat that has a portable gas cylinder with LPG that fuels it, then there is no occupational health and safety implication. If, however, it's a permanent installation and you've had to have somebody come and put it in, that process in itself involves danger, as does the use of it. The installation of a gas-fired stove or heating system does require professionals, and that does fall under the Occupational Health and Safety legislation and the particular regulations made underneath it. Thank you very much for watching this Paddocks Club tutorial. I look forward to chatting to you in the discussion forum.